Hey everyone, welcome to another edition of The Bullet. My name is Paul Lathrop. I'm the Deputy Director of New Media for the Second Amendment Foundation. Joining me today from Southern Indiana, Alex Ooley. Alex is, of course, the host of the Forge of Freedom podcast and an attorney in Indiana, although, as I do say every time Alex is on, nothing we are about to say is legal advice. If you need legal advice, get advice from an attorney in your jurisdiction. Alex, as we get started today, what I really want to talk about, and we've been talking about it pretty much all this week, is the decisions out of the Fifth Circuit. There's been a number of decisions, starting with the case that was in the Fifth Circuit Court of Appeals, where the Firearms Policy Coalition won and an injunction. There's another case where SAF won an injunction, and there's a case where I believe GOA won an injunction. And what came out yesterday and what I reported on yesterday as we did the show was that all members of the Second Amendment Foundation, and I believe members of the Firearms Policy Coalition, have the Department of Justice has been, I want to say the word enjoined, but I don't think that's the right word. They're not able to enforce this pistol-based rule against members of FPC, SAF, and some others. Am I in the right ballpark there?
Yeah, I think so, although I want to sort of qualify that a little bit because there is still some ambiguity, and I think it may help to give some background here. So as you alluded to, the Firearms Policy Coalition has the Mock v. Garland case currently before the Fifth Circuit Court of Appeals, and for those who don't know, that the federal courts are split up into three primary levels: the district courts, which are the lowest level trial courts; the circuit courts, which are the intermediate appellate courts; and then the United States Supreme Court. So that Mock v. Garland case is at the intermediate appellate court in the Fifth Circuit, which is the Court of Appeals for Texas, I believe Mississippi, and Louisiana. And the Fifth Circuit Court of Appeals granted an injunction in that case, which is great news because it means the court believes that the plaintiffs here, the Firearms Policy Coalition, among other plaintiffs, are likely to prevail on the merits once the case is fully litigated. So this preliminary injunction enjoins, you used the correct word, the enforcement of this rule that ATF promulgated and which was set to take effect, full effect yesterday. It was actually in effect in January, but there was an amnesty period that extended through yesterday. So when the Fifth Circuit Court of Appeals granted this injunction, it was just a very short order that said basically the request for an injunction is granted. But it didn't say what the scope of that injunction was, who it applied to. So the Firearms Policy Coalition requested clarification. And the clarification, unfortunately, wasn't as precise as we might like it to be. Now, I think the Firearms Policy Coalition believes that it covers all members of Firearms Policy Coalition, even members who joined after the injunction was granted. Now, here's what I'll say about that. I think that's probably true, but it doesn't mean that the federal government agrees with that interpretation of the injunction, and doesn't mean that you might not get arrested and have to defend that in court after you get arrested. So I think the Firearms Policy Coalition has the correct interpretation, but it doesn't mean there's not still some risk of being arrested because the federal government interprets that injunction differently. And there's sort of there's time and sort of place restrictions here we can talk about. Do these injunctions cover members that were members when the lawsuit was filed? Does it cover members that were members of these organizations when the injunctions were granted? Or does it cover members that joined even after the injunction was granted. And then beyond that, does it cover members of Firearms Policy Coalition beyond the Fifth Circuit? And I think
that was going to be my next question is, I'm in the Eighth Circuit. I know you're not in the Fifth Circuit. You're, I believe, in the Ninth. No, you're in
Seventh.
the Seventh Circuit. So, what do people outside of Texas, Mississippi, and Louisiana do?
Yeah. So I think, and I agree with Firearms Policy Coalition, I think there is a colorable argument that it applies to Firearms Policy Coalition members nationwide. With that said, this depends on your risk tolerance because, like I said earlier, the federal government could interpret that differently, and you may have to prove, number one, that you're a member to them after you get arrested, and then number two, you'll have to convince a court that that injunction also applies to you. And so there is some risk there. Now, with that being said, I think if you were a member on the date the lawsuit was filed and you live in the Fifth Circuit and you're a member of Firearms Policy Coalition, I think you're clearly covered. After that, it becomes a little bit more tenuous. There's a little more ambiguity. I think you are covered, but it doesn't mean you won't get arrested and have to defend that. So that may not give people much comfort, but that's sort of the world we're living in at this point. And that's similar with the SAF and the Gun Owners of America lawsuits. Those are in the federal district courts in Texas.
Yep.
And I have those orders in front of me, and I think actually the one issued in the Second Amendment Foundation case was the best because, for instance, the Gun Owners of America injunction says at the end here, for these reasons, the court grants, in part, plaintiff's motion for preliminary injunction. Defendants are enjoined from enforcing the final rule against, this is the important part, the private plaintiffs in this case, including its current members and their resident family members. So does that mean current members at the time that the order was issued? Or what does that mean by current members? So there's some ambiguity there in the Gun Owners of America injunction. With respect to the Second Amendment Foundation case, it doesn't have that same ambiguity. And I think the court in that case is interpreting the injunction more broadly in the same way that Gun Owners of America, Firearms Policy Coalition, and Second Amendment Foundation are suggesting, and that is that it applies to members of each organization, no matter where you are in the United States and no matter when you joined. Again, all of these have some ambiguity in them. It depends on your risk tolerance. But I think certainly if you live in these jurisdictions and you were members at the time the lawsuit was filed, that's the safest interpretation, the most narrow interpretation. I think you're certainly protected. And then beyond that, it's not quite as certain.
Let me get some comments in here. This one from Mary on the Facebook side. She said, this is the clarity I've been looking for. For example, FPC members, GOA members, I'll be listening for a bit with you guys tonight. Well, thank you, Mary. And let me get this one up. Robert says, I'm a member of all three, SAF, GOA, and FPC, but I don't have a pistol with a brace. If someone wants to send me one, just saying. Well, I'm not going to admit on the air whether I have an AR pistol or not. I'm not going to admit whether the AR pistol that I may or may not have a pistol brace. Just saying that I wouldn't be going out, if I did have one and it did have a brace, I wouldn't be going out to a public range and plinking right now. That's where I'm going to leave that.
Yeah, I think that's good advice. And listen, if you don't feel comfortable that you're covered by one of these injunctions, there are, of course, the other options that the ATF has said you can take, which are not great options. Obviously, you can register, and I saw just recently, just a few hours ago, the Reload reported, Stephen Gutkowski reported that I think it was 250,000 have in fact registered their firearms equipped with pistol stabilizing braces, which is
Stunning.
which is a lot, but also extremely low in terms of a percentage of these that exist out there.
Let's put that in perspective. When New Jersey banned bump stocks, they said you have to turn them in or get them out of the state. The turn-ins up to and past the amnesty date for the entire state of New Jersey was 0. I expected the same thing when this pistol base ban came about, and you've got to register them. I expected the number to be minuscule. 250,000 is it actually says to me there's a lot more of these out there than even the government thinks.
Yeah, and I've seen numbers between 3 and 40 million. So there are quite a few out there. So this is still a relatively low percentage, but nevertheless, I don't think it's not an option that I would want to use if I were an owner of a pistol brace equipped firearm. Along with a few of the other options that ATF has said that we have. Replacing the short barrel with a barrel that's 16 inches or longer, I think is not a good option for most people. And you can forfeit your firearm to the local ATF office, which is also a terrible option.
Yes.
You can destroy the firearm. They're good at giving us terrible options here. Or you can remove the brace so that it cannot be reattached. So you can destroy it, alter it, etc., so that it cannot be reattached. Now, there's some debate about that, and attorneys have debated this. I've seen quite a few different attorneys commenting on this particular option. Some think that simply removing the brace is enough. I don't think that complies with the text of the final rule, which says that it has to be destroyed, altered in such a way that it cannot be reattached. Now, what some people are suggesting, and this goes back to the comment from earlier, is that you simply give it to someone else. I'm not even sure that that would be enough. You might sell it to them and then buy it back later, but I don't think just giving it to them with the understanding that they're going to give it back would necessarily be enough separation between you and the brace, according to the final rule. So, but again, this is sort of a spectrum of risk. How much risk are you willing to take, and how much risk are you comfortable with?
Absolutely. Let me get a couple comments in here quick. George on the YouTube side says, quite often for honest citizens, the prosecution is the punishment. The time and cost when the government goes after you can be enormous. It certainly can be enormous and enough to bankrupt your average Joe.
Yeah, absolutely. I mean, in federal court in particular is even more expensive than defending yourself in state court because, let's face it, attorneys generally don't like to go to federal court if they don't have to because there are certain procedural hurdles and just a lack of convenience that you have in state courts where most cases are litigated and where attorneys are typically more familiar because that's where the volume of their cases are. So generally, it's more expensive to litigate a case and defend a case if you're charged in federal court.
So let me add, I know you have to have a special bar certification to argue in front of the Supreme Court, the United States Supreme Court. Is there that separation between state and federal courts as well? Do you have to have a special lawyer license to go in front of the federal court in Indiana?
Yes. So there are 2 districts in Indiana, 2 trial courts in Indiana federal court within the 7th Circuit. There's the Southern District of Indiana and the Northern District, and you have to be admitted in both of those courts to practice in either of those courts, and that admission is separate from the admission to practice in the state of Indiana.
Okay. All right. Michael over on the Facebook side getting to another comment. Good comment. Good question. can't handicapped people be exempt from this brace issue? Alex, last I heard, no.
That's my understanding as well, and I think the ATF has that as one of the top FAQs on their website. I'm trying to find it here. If I can find it, I'll link to it in the comments after the show that specifically addresses that question.
And get a couple more comments in here from Robert over on the YouTube side. He going back to the registering bump stocks in New Jersey. He says, "Well, we have a lot of boating accidents here in New Jersey." Yeah, I understand that because some of that coastline you guys have, that's some pretty rough stuff there. I imagine there are a lot of boating accidents out there. He also commented, "Well, the final rule doesn't comply with the text of the Second Amendment, so there's that." And
Yeah.
My opinion, and I'm sure yours, Alex, this is going to go down in flames for a number of reasons, not the least of which is the ATF doesn't have the ability by law to do what they did. So this is going to go down in flames. It's just now we've got the injunction. It's waiting for the rest of the case to go through.
That's right. And luckily, I agree with the comment. I think that the final rule is a usurpation of executive authority and legislative authority. I think it's a violation of separation of powers. It violates the Administrative Procedures Act. It violates the Constitution. There are all sorts of problems with the final rule. And most of all, it violates the Second Amendment. The good news is that the Northern District Court in Texas, the Southern District Court in Texas, and the Fifth Circuit Court of Appeals all believe that the plaintiffs in these cases are substantially likely to prevail on the merits. And the Fifth Circuit, the merits panel, has asked for expedited progress in this case. So they are hearing oral arguments on the case June 29th, which is 27 days away as of today. But that is very fast for federal court.
Yeah, one of the complaints we often have about the courts is they don't move very quick. It took 11 years to get, after Heller, to get to the Bruin decision. Well, this case came about this year, and we're hustling through the Fifth Circuit.
Yes, yeah, and I'm optimistic that the Fifth Circuit opinion on this issue will be positive for our Second Amendment rights, our individual rights.
Yeah, get this one up here real quick. Facebook side, Michael says, "You have competition. Line Biden is on." Well, I'm not only better looking, I'm also currently seated, so not as likely to fall over. So you might as well just stay here and watch us. So, and yeah, let me get this one in. That button there. This is just another ploy to make the AR useless, like New York did with the SAFE Act. And there's another one that we're fighting it. It's going through courts. It just seems like the Second Circuit, which is New York, isn't as fast as the Fifth Circuit. I don't know what to say other than that.
Yeah, and we've talked about this a little bit before. Obviously, it will be wonderful when the Fifth Circuit ultimately rules in favor of the plaintiffs in these cases. But how quickly it gets to the Supreme Court, I'm not sure. Obviously, the Supreme Court prioritizes cases where there is a circuit split. So if there's a circuit where the court says that this final rule regarding pistol stabilizing braces is fine, it complies with the Second Amendment and the Administrative Procedures Act, then obviously there would be a disagreement among the circuits, and those are the cases that the Supreme Court prioritizes. Nevertheless, I think that this is such a huge gun grab and such a matter of public importance. It affects so many people and burdens so many people's Second Amendment rights that I think the Supreme Court could take it up without that circuit split, hopefully in the not too distant future.
When you get a comment in from the Facebook side, Mary says, Alex, are you familiar with the Connecticut laws regarding our Connecticut compliant others where we can't legally own a short-barreled rifle if we're not military or law enforcement?
I'm not familiar with that particular law, but that is a huge problem. Obviously, even if people wanted to comply with the final rule and register an SBR, in certain states it's unlawful to possess an SBR. So it sounds like that would be the case there in Connecticut.
Well, actually, we've got. I'm not going to be able to get all the comments. I'm sorry, they're just flying in. Trying to catch them before they roll off my screen. They're coming that quickly. Great one from Roderick. Roderick on the Facebook side wants to know, how would this ATF rule change fit in as an ex post facto law? I don't think that's been addressed in any of the lawsuits yet. Just that it's an illegal regulation is the way it's been going.
Yeah. So here, ex post facto obviously means retroactive, and I'm not aware that, like you, Paul, that it's been addressed in the lawsuits so far. But obviously, the primary basis for the challenges in these cases is that they violate the Second Amendment and they violate the final rule violates the Administrative Procedures Act.
Yeah, I want to. We've got like 8.5 minutes left. I want to go ahead and move on to. We do have some news to cover, and this is actually. This is a little bit of breaking news. It happened yesterday, but it happened again as I was on the air yesterday, so I didn't have time to get to it in yesterday's broadcast. I didn't even know about it until today, because once I shut down here, I've been on all day trying to get information in. I shut down so I can decompress. So I didn't even know about this till this morning. SAF brings aboard Chris Cox. This is from a media briefing that was released yesterday. The Second Amendment Foundation announced it is enlisting the aid of highly respected Second Amendment veteran strategist Chris Cox and his public policy/public affairs consulting group, Capital 6 Advisors, as we forge ahead in our effort to win firearms freedom, one lawsuit at a time. That name, Chris Cox, sounds familiar. You're going to find out why here in just a second. Cox spent 25 years at the National Rifle Association, including 18 as executive director of the NRA's Institute for Legislative Action, where he served as the NRA's chief political, legislative, and legal strategist. Away from politics, he founded an effort to enlist leading cultural brands and talents in the country music industry to promote a wholesome American lifestyle that includes a legacy of responsible gun ownership. I'm going to jump down here a little bit. I'm going to go to the comments from Adam Kraut and see here. We're bringing Cap 6 aboard in advisory capacity on a number of different projects, said SAF Executive Director Adam Kraut. SAF has been the nation's leading force in the Second Amendment litigation world. As we look towards the future, I'm humbled and excited to have another major influence in the Second Amendment sphere, along with this talented team, as an available resource to help implement ideas and shape SAF's trajectory in the next 50 years. And then a quote from Chris Cox, "We're excited to work with Adam Kraut and the team at SAF. The Second Amendment faces unprecedented attacks, and America's law-abiding gun owners deserve real and transparent leadership. I'm proud to deploy my decades of experience advancing the cause of freedom alongside a team I respect and trust. SAF's best days are ahead of it, and law-abiding gun owners everywhere depend on it." This is, in my opinion, Alex, absolutely huge news. The NRA's loss is the SAF's gain. There's issues at NRA. I've said it a million times. I'm not going to say it anymore. But when they got rid of Chris Cox, that left a huge void. And I'm glad Chris Cox is coming over to SAF to help Adam Kraut.
Yeah, I mean, I'm looking forward to hear what sort of projects they have going where they could use the assistance of Chris Cox and Cap Six. I think it's a good sign. I think that Chris Cox has a great experience and lots of connections. So that I think this is great news. Obviously, he got caught up in the mess that started there at the NRA annual meeting in Indianapolis in 2019.
Yeah.
And got sideways, I think, with Wayne LaPierre. But that doesn't mean he obviously can't be effective through other great organizations like the Second Amendment Foundation. So this is awesome news.
Yeah, absolutely. I'm hopeful things turn at the NRA and go the right direction again. I would love to see that. I love talking about SAF's victories. I love talking about Firearms Policy Coalition victories, Gun Owners of America. It'd be nice to get talking about NRA's victories in court again. I would love to hear that. And I hope we get back to that.
Yeah, the NRA has been noticeably absent from a lot of this news around the pistol stabilizing brace final rule. But luckily we have these other organizations that have stepped up to the plate. And I'm sure a lot of people have already joined these organizations, but if you haven't, consider joining all of them or at least one of them. They're all excellent organizations.
Oh, yeah. I have nothing bad to say about Firearms Policy Coalition at all. I have no complaints about Gun Owners of America. There is an organization based out of Colorado that I do not much like, but we'll leave that there. Next story, the last story we're going to be able to get to today, we've talked previously that there's going to be a special legislative session in Tennessee. It's actually coming up starting in August, the end of August, that special legislative session is. And I got this story that came across my feed today. Tennessee Governor Bill Lee's administration accused the National Rifle Association of wanting to use involuntary commitment laws to round up mentally ill people and deprive them of their liberties, according to documents filed by the Republican staffers as part of their initial attempt to pass a gun control proposal earlier this year. The memos provided by Lee's office as part of a public records request reveal a rare criticism of the powerful gun lobby made by the Republican governor. Lee has previously praised NRA's efforts to protect the Second Amendment, but has since faced opposition from the group as he works to pass gun control legislation in response to a deadly Nashville school shooting that took place back in March. I find it interesting that Lee is trying to say he's really switching gears here, man. He's trying to say the NRA just wants to round up everybody that's got a mental issue, a mental health issue, and put them into hospitals where they can't get out in public. I'm just wanting to take away their guns. That's all I want to do.
Yeah, I think he's feeling the political pressure from the gun ban lobby, and unfortunately, it sounds like he's caving to it. And there are these mental health commitment laws in all 50 states, and rather than focusing on guns and depriving someone who's dangerous of firearms, the mental health without due process, these mental health commitment statutes have due process built in, and there are certain protections, like if you're entitled to an attorney, if you can't afford one, a medical professional has to provide an opinion, all sorts of protections that you don't get with red flag laws, because no matter what provisions are in red flag laws, they all deprive the person of due process by taking their liberty away first and then giving them process later. And that's not how due process is supposed to work.
Amen. Well, we are down at the end of the time we have. On the way out, Alex, as I always do, I ask you to tell everybody about Forge of Freedom podcast and anything else you feel like plugging today, man.
Yeah, so I started the podcast Forge of Freedom at the beginning of the year. Obviously, I care deeply about firearms and our right to keep and bear arms, but I care more broadly about freedom. And the podcast is about all things related to freedom. I want to give people the knowledge and the skills to build a freer life and create a freer world. So we talk about all sorts of things related to freedom, and including firearms. I have my dad, who's also an attorney and a firearms instructor, on every Monday to talk about a firearms-related topic. And the episode that's released on Sunday is a more general and more broad topic, typically non-firearms related. So if that's of interest to you, check out Forge of Freedom on YouTube, on Rumble, or on any popular podcast streaming platform. So definitely check that out. And the fight with respect to this final pistol brace rule, the final rule regarding pistol stabilizing braces, rather, is not over. And so don't get complacent just because we've got this injunction. There's still a long fight ahead. If you haven't joined Second Amendment Foundation, Gun Owners of America, or Firearms Policy Coalition, definitely consider doing that, because there's still a long battle ahead of us.
Amen. I will absolutely echo that. And if you are a member, please consider sending an extra $50. These lawsuits are not cheap. We've got a lot of members, but once you paid a $150 lifetime membership, like I have, yeah, they got your $150, they got your name, but they need some more continuing money. And even though I'm an employee, I'll sometimes send them money back and give them an extra, because I want these lawsuits to go forward too. So that is going to wrap it up for us today. I do want to encourage everybody, please do come join me tomorrow night, 7 p.m. Central Time on Saturday. Tomorrow's commentators for the weekend show are going to be Dan Waz, Rick Ector. Let me get my calendar back up here, even though I just said it 30 minutes ago.
Tony Simon, I think, was the third one.
Tony Simon is coming back. Rick Ector and Dan Waz will be tomorrow night. So thanks again, everybody, for watching, and we'll see you next